topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Orlando, one of my favorite cities. I live in the southeast part of Florida, but I love Orlando. But I really love the show we've got for you today. It's the last Thursday of the month. It's actually the last day of the month. And that means K. Bender Rimbaum. And I'm going to tell you something. This guy, this expert, I call him my bud now. I love doing the show with him. He makes it so easy. And by the numbers of people who write us, bro, they love you. You're like this superstar. Let me introduce you to board certified attorney Alan Swartzide. Good afternoon, bro.
Afternoon.
People
you really don't have to butter me up every time I'm here. I appreciate it. Don't get me wrong, and I'll take it every time. But it's not
better.
I'll still show up even if you don't.
People love you, and you make it so easy doing the show. Hey, if you're watching on YouTube, you can see all the classes that are going to be next month, but we will be announcing them during the show. I got to tell you, this is a very busy man with all the new laws that he's going to have to explain to everybody and to still have time to come on our show. Alan, tell people about K. Bender Rimbaum.
Sure. Well, our firm's been in place since the early 90s. We've got 23 attorneys, 8 board certified in community association representation, 1 board certified in construction law. And all we really do is represent community associations. We don't really do pretty much anything else. We do start to finish, collection, enforcement, day-to-day guidance, amendments, whatever you need. We got you covered for, I'd say, 99.9% of anything that's ever come up during the time I've been with the firm. So, if you're happy with the attorneys that you're working with, if that's not us, feel free to stick with them. But if you're not really sure that you're getting the best level of service available in the state and you want to give us a shot, whether that's as secondary counsel or you just want to make the switch, feel free to reach out. You're going to see my email if you're watching this on video in the top right of my picture. It's as@kbrlegal.com. That's the easiest way to reach me.
I want to share something. A lot of people, I've been doing this show for 15, going on 16 years now, and that's a lot of due diligence. When you've got a law firm that I would say 95% totally looks at community association law. And the reason why I say that, because you would not believe all the law firms out there, if you look at what I call their shingle, it'll say business law, real estate law, bankruptcy law, tax law, and then they'll say community association law. I'm telling you, you want a firm that basically totally looks at community association law. And I love the fact that that's where your concentration is. And I also love the fact that you really cover most all of Florida.
Yeah. I mean, we've got the offices in Pompano. We've got one in Palm Beach Gardens, Miami by appointment, Tampa, and I manage the one here in Winter Springs. So, and we do go as far north as you need. So anyone that's listening outside the Orlando area, although I do focus my practice closer to Orlando, we're not limited. We do practice statewide, as Steve mentioned.
I've got to ask you, there's a lot of new laws, and we'll get into that next month. But I want to ask you, it seems like most of all the new laws, Alan, are geared towards condo and not HOA. Why is that?
Well, I've heard through the grapevine that the legislature saw what they did to, not for HOAs over the last 2 years, and decided to finally give us a freaking break. That's pretty much it. I mean, it's we've been beat up in HOA land for 2 straight years, rights being taken away left and right. And it's great for the individuals who live there on a temporary basis. But when you take away enforcement rights in communities that were supposed to have them for the last, I don't know, potentially 60, 70 years, you're really creating more problems than you're fixing. But bottom line, the laws are what they are. There are ways to maybe work around them, and that's why you hire an attorney.
Well, speaking of the laws, I've got to ask you this. So there's a lot of new laws out there, folks. I got to tell you, you spent what, 2 hours today talking to community association. Just give us, and then we've got so many questions that have come in. Give us your of all the new laws out there, maybe one of your favorite and one of your least favorite.
Oh, ouch. Okay.
Ouch is for the least or for the favorite?
I'm not sure. When I talk about my favorite, it's really just fixing problems that were created, in my opinion, by previous legislation. So, one of my favorites is the ability to get a loan or a line of credit or levy a special assessment to pay for these structural integrity reserve studies and the reserves themselves, or maybe just the reserves themselves. The ability to fund that when the legislature's been telling us since 2022, you got to make sure you have this money. You're going to have it. And if you don't, then it's a breach of fiduciary duty and this and that. They finally at least gave a couple new avenues to get that money for the association so that people aren't just out of pocket. It was really a measure that was intended to prevent some of the foreclosures that a lot of us have predicted since 2022, with people that simply can't afford being on a fixed income to suddenly have an increase of, a couple $100 a month in assessments. People that, they budgeted for what they could barely afford, and now you're increasing their assessments by $500 in, not necessarily a great community, but just one where you happen to have a building that's more than 3 stories that's a condo. Bottom line, I do like the fact that new funding method is now allowed according to statute. I like the fact that the legislature put in the statute finally that pooling of these structural reserves is allowed. You can have a separate pool for non-structural. We've always, as a firm, kind of said, yeah, it's probably okay, but be careful because it's not directly in the statute. Now it is. So those are 2 of the ones that I did like. I think the legislature is fixing some of the problems, or at least trying to alleviate the problems that people are having. Not that the legislation itself was problematic, although my personal opinion is that some of it was, but they're trying to make it easier for people to afford what they're now required to afford. When it comes to the ones that I really didn't like, honestly, I think this email voting thing that came about in this year's legislative session is a election fraud waiting to happen. Because the statute doesn't require any proof that the person who's submitting this email vote is actually the person that is allegedly voting. You digitally sign by typing your name to say that you're the person that voted. Well, I mean, I would never do this. You would never do this, but there are many people who, in order to accomplish whatever the vote is, will just send emails from 5 different email addresses claiming to be 5 different people. And, that's election fraud. It's a crime, but that doesn't mean it won't happen. And I don't think the legislature is supposed to facilitate fraud. So hopefully there will be a fix. I'm already on an unofficial task force of the Condo Committee of the Florida Bar to propose some changes that might be made to clean some of this stuff up. So I think that the right to vote via email when there's no electronic voting allowed, it's a mess. And frankly, I hope that instead of it becoming a basis for a whole bunch of fraud, it becomes a basis for a lot of communities that weren't using electronic voting to now go out and find a vendor to use it so that they don't have to accept these emailed ballots. And again, that's only in condos, so at least it's not HOA, but we've also seen that the legislature kind of pushes the HOAs into the condo box over the last few years. A lot of the changes are made in condo land, and then suddenly 3 to 5 years later, HOAs are required to do the same thing. So I really hope that this is cleaned up with at least some kind of verification that the person who is allegedly voting is actually who they say they are. But yeah, I won't go into all the others because there's a couple other ones that I really don't like. But there are a couple that were intended to clean up and make it feasible for people to practically comply with previous statutes. Those are the ones that I think they're a little less clear than I'd like them to be, but the intent was definitely good, and I think the result overall is definitely beneficial. So that's a lot of words to say. I didn't like most of it, but there were some good things there.
So I don't want to throw us on the fire, but is it true that all these lawmakers in Tallahassee, that only one of them actually lives in an association? Is that true?
So my understanding is that there are only one or two that are actually involved in promoting this particular legislation that actually live in a condo. So it's, plenty of them probably live in HOAs. And let's be realistic, that's usually how the laws come about. Someone sees in their own community that something bad is happening and they decide to fix it through legislation. The problem is the legislative fix is almost always going to cause more problems unless you really rely on the expertise of the attorneys that practice in this field and are in, on the boots on the ground on a daily basis. And I don't think there's enough of that going on when these statutes are proposed. I know that there are certain groups that do get to meet with legislators, but I don't know that they're actually heeded and listened to other than the general concepts that they're pushing forward. There are a lot of, we call them glitch fixes that are really needed. And I think we could avoid a lot of those glitches if there was a little bit more communication and a lot more listening by the legislature to people that did what my firm does, who listen to the boots on the ground on all sides, the developer attorneys, the HOA attorneys, and the owner's side attorneys. I think the developers have a much bigger lobby because their hourly rates are usually 2 to 3 times what we charge. And so they have more money to throw at these issues. I know my partners, especially Mike Bender, he's always been severely involved, I guess is the best way to put it, with the Florida Legislative Alliance that's part of CAI. We really try and make these laws the best they can. I participate in these task forces every year for the last 4 years, but there's only so much we can do to make the legislators understand the practical impacts that they're having when they're also faced with the individuals that are either voting or not voting for them, that they really need to, I hate to be blunt, they need to cater to them to get the vote. So it would be really nice to see a lot more balance being struck between the legislature's desire for votes and desire to do what is really helpful, which would be to have clear laws. But I do think that, their hearts are almost always in the right place and they really are trying. It's just a matter of, I think the level of communication should be higher.
So, Alan, I've got a public service announcement.
Okay.
Because we get so many people complaining about their association. And I get a lot of letters, people saying how hard it is to get board members. And I'm going to tell you something. If you have a lot of complaints, run for your board. Get on the board. Isn't that right?
Yeah, I mean, you can't fix it if you're not a decision maker.
Exactly.
If you don't like what's happening and your board is the one doing it, become one of those people and vote differently. I totally agree, Steve.
Yeah, it's so amazing. I've learned a lot over 15 years doing this show with you all. Let's go to, and by the way, if you've got a question that you would like for us to ask Alan, and boy, do you guys send them in, you can contact us at 954-336-3767. You can text it. We get so many of your questions. Let's see how many we can get on today. This is from Randy in Orlando. He wants to know, is it a good practice to delay putting the only elevator back in service over a weekend to save on overtime fees? Boy, people are watching their money, aren't they?
Yeah, I mean, honestly, I wouldn't advocate for it, but if the overtime is going to be, time and a half at $500 an hour, I don't know what the rate is for this particular vendor, but depending on the amount of people that are working, I mean, if you can save 10 grand or 5 grand by not having the elevator work 2 days quicker, it depends, frankly, how stingy your board wants to be. That's the way that I would look at it. If you're going to be completely fiscally conservative when it comes to how you spend association money, yeah, I can see an association doing that. I would definitely not advocate for it, but if you want to choose between having the elevator work 2 days later or have an attorney work on an amendment project for your association, I'd probably choose to spend that money on the amendment project or spend it on some kind of beautification to make the association a better place overall, not just on those 2 days. But again, it really, from my perspective, it depends how much money you're saving by waiting, to pass the weekend first. Now, if you've got people in the community that you happen to know are disabled and not really able to get downstairs without that elevator, that might be an impetus to say, yeah, we really need to do this sooner.
We get a lot of complaints, people saying that their elevator is broken and they keep trying to get it fixed, but I'll save that one for another day. Alan, with all the electric cars out there, we get so many people asking, what can they do to get more, I guess, recharging stations on the property?
I mean, if you're in an HOA and you have a home and a garage, you can put one in your own home. That's a practical solution. But if you're in a parking
Yes, I think these are condo.
Yeah, I mean, if you're in a parking lot, whether it's HOA condo co-op, there is a statute that specifies what you need to do. I would just go under and search the Florida statutes for electric vehicle charging station, and take a look at that statute. Get in touch with your association requesting one, but understand some of that cost might be passed along to you to install it and maintain it, depending on where it's located. But there is a requirement that these be installed if there's a spot to install them. So again, I would take a look if you're sitting there with a Tesla and you don't have a place to charge it inside your garage and you're fighting with all your neighbors in Miami or in downtown Orlando to try and find that one spot because there's only one charging station in your 2,000 unit condo, it might be time to take a look at the statute and reach out to your association, reach out to the manager or the board and ask them in accordance with that statute to install additional charging station for you.
We're in hurricane season now, and let's just knock on wood that we don't have any major hurricanes this season. But we've got like 3 or 4 questions from people wanting to know if the neighbor's tree, and it seemed like they always say on there, we've asked them to trim their tree, but if the neighbor's tree falls on their house and there's major roof damage, who's responsible for that, Alan?
Ask the insurance company is really my answer. I mean, that is the quintessential reason to file an insurance claim, in my opinion. Who's responsible might depend on whether the tree was diseased or dying. It really comes down to a lot of different facts. But if that was a healthy tree it gets hit by an act of God and falls over because it was struck by lightning, I don't really know that the owner whose tree it was will be held liable. It's whether there was any real negligence in having a tree in general. If there was nothing wrong with the tree, why would they have any reason to know that it would get knocked over in the middle of a storm? So again, I mean, your insurance carrier is the one that I'd be talking to about a situation like that. There is guidance on, I call it tree law. When you've got the branches that are falling over, or a tree that's dead or diseased, or that are just, hanging over the fence line, so to speak, the boundary line. The University of Florida put that out, I think, in 2017, and it's still accurate. So I would look up the UF statement regarding tree liability. I don't remember exactly what it's called, but that's a really good resource. There's only 2 or 3 cases that are cited, but it goes through almost everything. Unfortunately, it doesn't address the issue mentioned in the question, which is why I'm mentioning it separately.
I'm going to get this last question before we go to break. I know
Sure.
this has got to be from your cousin Beth in Orlando, Alan. She says, I hope that people realize that you take a lot of your time to help educate us. I know you're busy during the day, but I just wanted to tell you we can't thank you enough for giving us this time each month, and we really appreciate what you do. I know that was your cousin. You had her right that that's okay.
Well, I
Uh,
didn't hear a
she
question,
wants
but
to
thank
know
you,
though.
Beth.
Here's her question: what can
Oh,
a
okay.
member do to enforce a violation? The ARC states that they will not be enforcing certain violations like running a business out of your home or not following color book.
So
HOA.
in a lot of instances, if you look at, I think it's 720.305 for an HOA is the statute number. It'll say that the declaration can be enforced by the association or any member, or I think that's 4 categories of who can enforce. So you've got that statutory right to enforce the declaration. I mean, if you want to file a lawsuit against your neighbor to try and force them to comply with the architectural standards that you're talking about, you might be able to find a lawyer that'll help you out with that, or you might be able to do it yourself. But, the bottom line is you generally do have the right to enforce the association covenants and restrictions. You probably wouldn't be entitled to any damages or anything like that. But you might be able to get an injunction to force them to comply. The only hitch there is you mentioned that the ARC is not going to force them to comply. The question is whether that includes the ARC actually approving the conditions that you don't like. And if they actually approved it, that probably will not be something you're able to enforce because it was authorized by the association. So I would just take a look at, again, I think it's 720.305. Take a look at your declaration as well. That probably says that this document or this declaration can be enforced by any member. It usually will be in the enforcement provision of the declaration itself. But, when you ask, what can I do? You can do the same thing as the association. It's just that you need to keep in mind that when you choose to pursue that enforcement, you need to comply with the same pre-suit requirements that the association would. And it's going to be on your dime, not the association's dime, that you're pursuing this lawsuit. So you're going to have to be prepared not only to spend all of the attorney's fees and costs, if you have any attorney's fees, because you're hiring counsel, that it would cost the association to pursue this, but also presuming the owner wins or the other owner wins, you got to be prepared that you're going to have to pay their attorney's fees and costs if they hire an attorney. So it can be a lot more costly for one person to pay for this than the association paying for it. But if the association's refusing, keep in mind, you mentioned that the ARC is refusing to enforce it. You might talk to the manager or the board to find out whether they are separately enforcing it. Because in most communities, it's not the ARC that enforces this stuff. It's actually the board.
We're going to go to a break. Alan, tell people you've got 4 offices, but if they want to reach you in Orlando, how do they do that?
Sure. Well, it's perfect timing. It's right at the bottom of the screen now. 954-928-0680 is the number that'll reach anyone in any one of our 4 offices. Again, 954-928-0680. The easiest way to reach me, given the fact that, as Steve mentioned and as Beth mentioned, I am not in the office all the time, but I do have email on my phone. It's as@kbrlegal.com.
Okay, we're going to go to break. We come back, we're going to go over. You got a lot of classes coming up in August. We're going to go to break. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. This is the Ask the Expert show. It's last Thursday of the month. That means K. Bender Rembaum. We're here with board certified. I love that, how that ring sounds. Board certified attorney Alan Swartzine. Alan, gosh, I love how your firm makes education so important. And you walk the walk. I got to tell you, every month you've got so many classes that you do, free classes. So let's go over what you've got coming up so far for August.
Sure. So August 6th, we've got a class on guest restrictions, basically what you can tell people they can and can't lease or buy into your community. That's going to be by Kirsten Henza in our Tampa office. We've got your show actually on the 7th with Robert K., my partner. I'm going to be teaching an HOA board certification class on August 8th, and that'll be in Osceola County and Kissimmee. That's actually at Empire Management Group's trade show. So I'm the main event before the trade show, and then the trade show starts at noon, I think. We've got a August 20th HOA specific. For those of you who've been waiting over a year for DBPR to approve the classes, we finally got the authority to teach these HOA education classes that are specifically for HOA board members. That one is going to be on the 20th. Again, HOA financial literacy and transparency. That's going to be Kirsten as well. We've got another HOA board certification class by Danielle Brennan, who's in our Palm Beach Gardens office. That one is online on the 21st. We've got the Ask the Attorneys in Tamarack if you want to take a very long drive. And then we've got an HOA board certification condo board certification, which I'll be teaching along with someone on August 29th. We haven't really decided who's going to co-host that one, but it's a 4-hour class. And eventually I do need to shut up for a couple minutes. So after 2 hours, I give up and someone else can take over. So that's, as of now, what we've got scheduled, but it's not even August yet. My guess is we'll have 4 or 5 more classes added by the end of the month. I know I'm not teaching any of these HOA-specific classes yet, and a couple of my clients have been asking for them for literally a year, and the DBPR finally did what we need them to do to authorize us to teach them. We were, I think, one of the first 5 firms, as usual, that was actually authorized. It's not that we had to be held up for a year. It's that everyone was held up for a year. So my guess is we'll probably add 1 or 2 of those that I'll be teaching, possibly along with my associate Chuck Nix, and we'll go from there. But we've got, I think it's about 10 classes that are scheduled this month so far. I'd be surprised if we don't hit 15 by the end of the month.
Wow. So here's a personal question. K. Bender Rimbaum is one of the largest community association law firms in Florida. How are you working this out with all the new laws now with all of your clients?
Well, I mean,
Are
the
they
reality
falling
is,
up? How are you
no,
doing it?
I'm not. My partner, Jeff Rembaum, is. That is one of the benefits of working with a firm like this, is that we have the legal morsels that Robert Kay and Andy write a lot of the time. We have Jeff Rembaum's Roundup, and all these are available on our website. They're really just articles and blog posts. But, Jeff puts out a fantastic legal update that's about 20 pages. Last year it was 40. It's a lot shorter this year. But he puts one out every year, and he gets input from a couple of the different attorneys, including myself, as to how to draft this. He did a fantastic job again this year, and that's all available on our website. So when clients ask, what can you tell me about House Bill 913? My response is, here's a free article. Have a nice day. Call me if you've got any actual questions, but you're not getting billed for me to send you the article, because that way it's just honestly easier. And, we're not dying for work. We're happy to work with the new communities. But the bottom line is, I don't want to charge a client for something that we've already done. If it's already available on our website for free, because Jeff has given his time to prepare that, we've got 4 or 5 webinars already that have been recorded. I think Jeff and Mike Bender did a Castle Group webinar just the other day, or I think they've got 2 or 3 alone, where we're just going through these new laws. So the bottom line is, I refer my clients to the website. I hope that they take advantage of it. And if they'd rather pay me to spend 4 or 5 hours writing an email about exactly what's going to impact them and how, that's fine. But if they'd rather get the free resources that we're already offering to everyone, I'm happy to have them do that. And I can move on to other work and make sure that all of my clients are happy, instead of just billing as much as possible.
Jerry in Winter Park, is it okay for a condo board president to walk through the community answering residents' questions about HOA business?
Not something I'd recommend, but it's not illegal. There's no statute that says the president can't be fully transparent. My concern there is that when you keep all those communications verbal, someone takes something the wrong way, and all of a sudden the association's being sued because someone misunderstood what the president told them. So my suggestion would be not to do it. But when Jerry's question is that problematic? Is it illegal? No, it's okay. It's just not something I'd advise any client to do.
Richard didn't leave us a city. He said many residents are installing spotlight audio video cameras on their garages. Does this require a vote of the community?
It depends whether you're in a condo, HOA, or what. If you're in an HOA, chances are this is not something that would require a community vote if it's just one member installing something on their lot's garage. But if it is, keeping someone up at night because of the light, or if it's impacting another lot, that's something that you might take up with the board. But generally speaking, if you're in an HOA, this isn't something that would require a member vote.
Don in Orlando wants to know if a current board of directors member hits the 8-year term in a year and a half into stretches it to 2-year term, is he or she automatically off the board, or does he or she finish that term before being termed out?
Good question. I've been trying to get clarification on this from the legislature for a little while. Unfortunately, we don't have a clear answer. The legislature says you can only serve for the 8 years, keeping in mind that 8 years won't actually kick in until July 1st, 2026. So this isn't really an issue we need to deal with yet, because the law went into place in 2018, and it is not retroactive. So we won't need that answer until July of next year. But the statute presently only states that you can't serve more than an 8-year term consecutively. What it doesn't say is that you can't drop off and be appointed back and start a new 8-year term. What it doesn't also say is that you're automatically off if you've served those 8 years. And keep in mind also that there are exceptions that are written directly into the statute where, if a certain percentage of the members vote in favor of it or no one else tried to get on the board and nominated themselves, that's all a basis for that individual to stay on the board even though they've served the 8 years. So there's nothing that's remotely clear from my perspective that this is automatic, or that the director serves for the rest of the term and then at the new election can't be elected again. Because here's the thing. Again, that exception states in particular that they can serve again, but only if certain conditions are met. So I don't think that this is something that anyone will be pulled off automatically, but I can't say with 100% certainty because the statute doesn't give me 100% certainty.
Edwin in Winter Park said, I usually start off with only about 10 or 15 minutes of listening to your show, and I always find myself staying for the entire show. I appreciate your efforts and your knowledge. Thank you so much. My question is it true a board can only enforce the new covenants on the homeowners that voted for it or purchased their house after the covenant was enacted?
So, and first of all, thank you for those kind words. It's always appreciated because it is, I was going to say it's fairly rare to get that appreciation and recognition, but when I'm on this show, Steve always likes to point these out. So I can't say it's that rare here.
Your
it's
cousin,
in real life, I have that problem. But anyway, so the application of an amendment only to the people that voted in favor of it or bought in afterwards is only going to pertain to leasing and sales restrictions that are being added into the declaration. In a condo, that's going to be the case for all leasing and sales restrictions. In an HOA, there are actually statutory methods that you can use where certain aspects of the leasing and sales restrictions, it's actually just leasing. I think it's if you restrict to no more than 2 rentals in a year, 3 rentals in a year, and terms of no less than 6 months. I'm pretty sure that's it under Chapter 720. But if those 2 separate terms are, or one or the other, are what's included in that leasing restriction, it'll apply to everyone across the board. So again, this is only going to be for leasing and sales restrictions. And in a condo, it's for everything. For an HOA, it depends on the content of the restriction itself.
Edwin in Winter Park, is it true? Karen in Orlando. Is there any legal recourse that can be taken against a board of directors if their decision to cancel a no change color contract for a 50-year restoration project ultimately turns out to cost the association more?
I mean, whether there's any recourse, I don't think there would be any financial recourse. Generally speaking, the directors in the association are protected by what's called a business judgment rule. And that's basically where if it's a business decision and it's not completely unreasonable, there's no self-dealing or arbitrary decision-making, the directors are generally protected. So what your recourse might be is to elect new people next year. I just don't think that there's going to be any financial recourse that would be available for this particular, according to the question, this particular potential mistake. And the other question is, was it actually a mistake? And is it a mistake you can prove? If you're saying that the decision was not to change the color, that might be because the board didn't think it could get a material alteration vote and decided to stick with the color that was already there, even if it costs more, instead of throw away the time and the effort and the money as a business decision that it would take to try and get that material alteration vote.
Steve in Orlando, I know a law was passed about restricting work vehicles with writing on it. Is that for condos as well?
No, no, that's HOA only. And keep in mind, as we've discussed in past episodes of the show, that's really questionable as to how enforceable it is if you don't have special Kaufman language in your declaration. That's basically adopting the HOA Act as amended from time to time. So again, those restrictions are only going to apply to an HOA, not a condo or a co-op, because they're only in Chapter 720. And I would suggest conferring with your attorney as to whether it actually applies to your particular community or if your declaration, which contains that covenant, actually controls over the statute.
Let's see, Greg in Claremont. May any part of a vendor's contract be in Spanish for a condo?
I don't know of any law that says no, it can't be. So I'm going to say that it can. But obviously, your directors are subject to actually being able to understand the terms that they're signing. So if you don't have a director that can accurately translate that, I would say there shouldn't be anything in there that is not easily comprehended. The other thing is, hopefully you're running this by counsel if you're signing a contract. And so hopefully you've got an attorney in that instance that also understands Spanish. And you and determine whether those terms that are in Spanish and in English are actually problematic. I would not, frankly, be willing to sign something that is not in English, or have one of my boards sign something that's not in English, because the reality is the cost of getting someone to translate that for purposes of court, if there's ever a dispute regarding that contract, would be way more than most instances the value of the contract itself. And if you have to hire a translator, they usually will charge $15 to $20 per page in my experience. And if you've got a 5-page contract, just having it translated and getting this person to come into court and testify could cost more than the cost of the services that are being rendered pursuant to that contract. So I would make sure, frankly, that it's all in English, but I'm not aware of anything that says it can't be in another language, as long as the person that's signing and the people that are discussing it have it translated to accurately understand what it says.
Trish in Orlando, condo. I want to thank the people who let us know that they're a condo or HOA. We so appreciate that, because it makes such a difference. So here's Trish in Orlando. She's in a condo. Are we allowed to have a line item on our budget for social events? Must we have a community vote, or can the board just vote on it?
Well, I mean, it depends whether the declaration is written in a way that would allow that. There's nothing condo or HOA about this question, although I certainly agree with Steve. Thank you very much for clarifying which one you're in. This would apply across the board to all community associations. You need to look at your governing documents and see what you can levy an assessment for. Is it for the benefit of the members or the benefit of the community, or is it purely for the health and safety? A lot of times it'll say health, safety, and welfare. I could probably create a creative argument that says that these social events are part of the welfare of the community. It's really a matter of, I would get an opinion from your actual association council to say whether it's okay or not. I have no problem overall with these types of events, but one thing that I do recommend, if you're going to consider putting them on, run that idea by your general liability carrier to make sure that that's not an exclusion and that it's actually going to be covered if something goes wrong and you get sued, that your insurance carrier will cover that claim. Because if not, if someone, dies, someone gets hurt, and these are events that maybe shouldn't be association sanctioned and it's not covered as a result, the association could be out a lot of money. So bottom line, I don't see a huge problem with it, but I get advice of counsel and I get advice from your insurance agent to make sure that your policy is going to cover this.
Barbara in Winter Park, she's a condo also.
Okay.
Doesn't committee meetings have to be posted and owners are allowed to sit in via Zoom?
Well, there's no automatic right to attend via Zoom at any meeting unless the meeting's being held via Zoom. So that's step one. And then whether or not you're entitled to attend that committee meeting depends on what's being discussed. And what's being discussed should basically be based on what's on the agenda. If there's nothing on the agenda that talks about architectural changes and nothing on the agenda that talks about spending association money, recommendations to the board to spend association money, generally those committee meetings are not going to be open to the members. So I would like to say, yes, there's the transparency and, everyone thinks of the sunshine laws, even though they don't actually apply to HOAs or condos. But the reality is the statutes don't actually make those meetings open to the members unless there's certain subject matter being discussed. So that's another one I would check with your attorney if you are on the board side. And if not, you might check with an attorney that doesn't represent community associations to find out what the statute says about the specific type of meeting we're talking about here.
Stephen in Orlando, can a 718 condo association change their budget mid-year without notice to owners and a board vote?
Not without notice to owners, not without a board vote, but it could be that they do it via what we call a written resolution. And if that written resolution is unanimous among the directors, then it takes the place of a board meeting. So that might be one other way to do it, but not without any kind of notification. You can't just change the assessment amount, which is really what you're doing when you change the budget. There should be notice to the members. Now, that could be the unanimous resolution followed by notice that the next assessment will be more. So I just don't know offhand what notice, if any, was provided, or if it was just that the board decided we're going to change the assessment amount, which they can't really do.
Chris in Orlando wants to know, is it legal to assess unit owners before a contract repair is approved and signed?
Yes. Because keep in mind, when you levy that assessment, it means that you're telling someone that they have to pay it on a certain date. You want to have the money before it comes due under that contract. And if you're telling people we need to have the money in advance, that's actually just a logical move, because most contractors are going to say you got to pay a certain percentage up front. If there's no assessment towards that dollar figure before you sign the contract, where's that money supposed to come from? So logically speaking and legally speaking, I don't see a problem with requiring payment before the contract is signed if you know you're going to do the work.
Kathy in Claremont, another condo. What if a board calls for a workshop to avoid committee meetings? Do they still have to give us notice?
So same answer regarding committees. There's really no such thing as a workshop. It's not created under statute. It probably doesn't exist in your governing documents. So again, that is still a committee hearing or a committee meeting if that committee is meeting to do what it would normally do during a meeting. Now, I am one of a couple attorneys in the state that has the opinion that if there are no decisions being made, no business can be conducted, and that is really not a meeting. But there are plenty of attorneys out there that'll say, as long as a quorum of that committee is meeting, and if it's one of the statutory committees that requires notice, that notice is required, even if you call it a workshop. So it really comes down again to what's on the agenda for that meeting, what's being decided or discussed.
I'm going to get our final question in.
Okay.
This is from our YouTube, Deborah. If the statute states material changes are voted by owners, but the condo docs say board, we have Kaufman language. Which rule is followed by the condo?
If you have Kaufman language, most likely you will be following what's in the statute, because the statute, actually, let me restate that. I'm actually very wrong on that one, because the statute specifically says unless the governing documents say otherwise in this particular instance. Some of those statutes don't. But the statute talking about material alterations in a condo specifically says, unless the declaration says otherwise, the percentage is 75% of the members, I think is the percentage. If your declaration says the board gets to decide, my opinion is the board gets to decide. Now, keep in mind, there's also case law that talks about if you're doing a material alteration that's for the benefit and protection of the association, or that's mandatory maintenance that you're performing, you might not need that member vote, even if the statute applied or if your declaration said you need a member vote. So I wouldn't presume that a member vote's required, but in that specific instance, I would suggest that you probably would stick with the board being able to vote on the alteration.
Well, believe it or not, Alan, we did it. You did it. That's going to do it for us today. You've had a long day today. Tell people how they can reach your office and your website.
Any office of the firm, again, 954-928-0680. Reaching me, the easiest way is going to be email or going on LinkedIn, and hopefully not overrunning me with direct messages. But you have the spelling of my name here. The easiest is, again, email as@kbrlegal.com. And if you want to see all those upcoming classes that Steve mentioned or the ones that we've recorded previously, just go to kbrlegal.com.
Well, bro, listen, first of all, great news is you'll be back with us next month. I really enjoy doing the show with you. Hey,
likewise.
Thank you for everything. The listeners love you. I love you. And we'll see you next month.
Thanks, my man. Appreciate you having me. Thanks, everyone, for listening.
That's board certified Alan Swartzide. Hey, that's going to do it for us today. Thank you, Juan. Another great job. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Experts show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.